Hello again. My name's Laurie Ohall, and I am a Florida board certified elder law attorney. And what that means to you is I am an expert in elder law and estate planning. And I like to help educate the public. Today, I want to talk to you a little bit about the questions that you need to ask when creating an estate plan. A lot of people hear the word estate plan and they think, "Ugh, I have to have a lot of money and I don't have that much. So why do I need an estate plan?" But that's actually not the case. You may have a house or you may have some bank accounts. Those are assets that need to be accounted for in the event that something happens to you. How are they going to get to the person you want them to go to, whether that be your spouse, your children, whoever that could be. These are the things that you need to think about when creating your estate plan. Now, you can do this on your own, and there's lots of different softwares out there that you can prepare your own documents. And while that may have its place, a lot of times many times, most of the time, I think, it's better to use an attorney, if you can, because you don't know what you don't know. You may not realize that the way you write something in software that you get is saying one thing when you meant something else. So an attorney, their job is to know how to write a will, how to write the power of attorney, how to write the documents that you need to accomplish the goals that you want. So the things that you need to think about though when you're creating your estate plan, first thing is, what assets do you own? What is their approximate value? So when somebody comes into our office, before they come in, we send them an intake form, and it does ask that question. And the reason for that is we need to know what you own so that we can talk to you about how are you going to make sure there's beneficiaries for those things that you own? Because some things you can put a beneficiary designation on. You can, life insurance, you can assign a beneficiary. Your retirement accounts, you can assign a beneficiary. And some things you can't. In Florida, we don't yet have a transfer on death deed per se for your house. But there are other ways that you can transfer the house and avoid it having to go through a whole probate process. And I may be mentioning terms here that I'm not explaining because I've explained them in another video. So for instance, when I talk about probate, I'll put a link down below for the video where I discuss probate, or for an article that I've written about probate if you're not sure what that means. And then in the future I'm going to be doing more videos, so we'll have videos, we'll have articles. Yay. Okay. The next thing that you need to make sure that you answer: who do you want to inherit your assets? Is it a charity? Is it a family member? Is it your children? Is it your spouse? You need to write down who those people are. And it may be you want one person to have, bank accounts, and you may want another person to have your house. You need to plan that out and write down what you want, so that if you go to have those documents prepared, that information is readily available to whoever it is that's preparing the documents for you. Next thing you need to think about is, if you become incapacitated, who is going to manage your estate? So, let's say you get into a car accident and you have a brain injury, or let's say you have a stroke. But if you have a major health event happen and you can no longer pay your bills, who do you want doing that for you? Who do you want making healthcare decisions for you? Again, it doesn't have to be the same person. You could have one person managing your finances and another person managing your healthcare, but you need to have that in writing in whatever form the state that you're in requires, whether it's in front of two witnesses and a notary. There might need to be specific language in the documents to make it legal. So you have to have that in writing in order for somebody to be able to make those decisions for you. And I will discuss in another video why that's important if you don't have it in writing, because then it could lead to guardianship. So the next thing that you need to think about is, who do you want to care for your children if they're minors, if something happens to you? You know, obviously, if they're adults, they can care for themselves. Once your child's 18, they make their own decisions. So you have no more say so you might think you have say so, but you don't have any more say so. Um, but if they're minor children, if they're under the age of 18, you have the right to name somebody to become their legal guardian so that that person can take care of them and make decisions for them until they turn 18. So it's important, if you have minor children, to name who do you want in that capacity. Do you have any concerns about your beneficiaries or your heirs' abilities to manage what they're going to get? For instance, with a minor child, you don't want a minor child to come into hundreds of thousands of dollars, or even $50,000, because in Florida, if it's more than $15,000, we have to go to court and have a guardianship established, and that court monitors what happens with that money. And believe me, you don't want to have to put your family through guardianship, because it's a hassle and it's expensive. And when the child turns 18, they're going to get all the money that they would have inherited. So, you know, you don't want to leave a life insurance policy worth $100,000 to a child, because when they turn 18, they're going to get it. And do you know any 18-year-olds who can manage $100,000 without blowing it like that? I don't. If you have concerns like that, or maybe you have an adult child who has drug or alcohol issues, or who has special needs issues, is disabled, you know, maybe they have Down syndrome, or they're intellectually disabled, or you know, something like that, and they're getting government benefits and they can't manage their money. If you have any of those things, then having a trust set up for that, the benefit of that child, is the best way to go. Again, I can do a whole nother video why that is. And if I've written an article, I can post that in the links below so that you can read about it if there's not already a video about it. And finally, the other thing that a lot of people sometimes don't think about, but it's a simple question when you're talking about estate planning, is, what do you want to have happen to your body when you die? You know, do you want it donated to science? Do you want to be cremated? Do you want to be buried? I realize that, you know, the younger we are, people don't want to think about that, because you think you've got, you know, a lifetime to live. So it's never too late to make arrangements. Usually, though, my older clients are the ones who will prepay that kind of thing, because you know, they don't want their kids to be saddled, or their family to be saddled with the cost of that. But it is something to think about. You know, what do you have any specific wishes that you want? If you can answer these questions, you're already one step ahead of what you need to do to get on track to have your estate planning in the right space. And if you have any questions and you're in Florida, you can feel free to look us up at ohalllaw.com. You can call us at 813-438-8503. Thanks for listening. Talk to you soon. Bye-bye.